let's go ahead and get started here. So what we're going to talk about today is some proposed legislation that is I think, going to keep coming up here for H2B. This was proposed last year during the omnibus time. That's usually when they do these things because getting an individual bill through Congress is very difficult. And so what they do is during omnibus, which is at the end of the year, they usually stick in all of these bills. The tailwind behind this one is the reason that I'm discussing it so early. I think that this one actually has some real shot of getting through. It also has some long-term implications for a lot of our clients. A lot of our clients are in agricultural construction, so they use the H2A program. There's a lot of efforts right now to remove construction occupations from the H2A program. Thankfully, the Department of Labor has not been one of the aggressors in the actual removal of construction, although I think that's because they really want to be able to. And they've changed some rules. They changed the wage rate methodology. Every time I see proposed legislation for H2A, it always excludes construction occupations, which then has another domino effect here. And so it's important that any of our H2A construction clients are paying particularly close attention to this and the people that rely on them. And I see this every time I see proposed H2A legislation, which actually happens to come up at similar times as the H2B legislation through the omnibus process. And so one of the concerns that I would have is that in some year, the H2A legislation gets approved the same year as H2B, and the employers that have been utilizing H2A to serve that function are just out of luck. So that's a concern that I have, and that's part of what we're doing here is we're trying to look forward for you so that you don't have to worry about that, and that you have some assurances that you have access to the labor that you rely on. This is also important for a lot of other people. If you're someone that uses H2B, I'll just tell you my initial responses to this bill when we get involved. So if you already use H2B, it's great information to have. It's information that you might want to use to plan forward, particularly with growth opportunities, and I'll get into that in a little bit. If you're someone that is using H2B and already doing construction, it's good. If you're someone that is looking to use H2B to get construction workers, it's terrible. But we'll get into all that as we go. I'm going to give you guys just my initial reaction. And for those of you that have been with me for a while and know how I generally view legislation, it's pretty cynically. I usually, when I'm reading through these things, there's a lot of red flags here and there. And, frankly, in this legislation, there's some. But this legislation is not all bad, which is normally what I see. When I see the proposed bills for H2A, for example, those are almost all terrible. And the people that are pushing those it's almost like they're trying to get legislation through for the sake of getting legislation through. That's not what I see here. So credit to the folks that have been involved at the negotiating table on this particular bill, because they're doing a great job. That's, they're doing a great job, and you see where they gave and where they gained, and it is an actual two-sided bill, which I don't see a lot of. So there is that. So give credit where credit is due, and I also think that because of that, this actually has potential to pass, which is another reason that I think it's important that we talk about it and that you plan for it, because I do think that there's an actual legitimate possibility that this thing passes. Okay, so let's talk real briefly about some content in the bill, and then I'm gonna go through what I think that you should be doing here. So let's talk about the bad stuff in the bill first. There's a few provisions in there that are particularly bad. One of them is the specific exclusion of construction occupations. This bill would and it says specifically in the language that it's to be liberally construed. Uh, that's not great, because if you're a construction company that hasn't used H2B before, and then you come to rely on H2B, say if construction is removed from the H2A program, and you would then be relying on the H2B program. If you haven't been utilizing the H2B program, you would be excluded. And so that's really bad. It would make it to where you just don't have access to your labor. It also prevents future people from being involved in the H2B program that want to use, that have construction occupations that they want to fill, which I think is really bad. I think that drives up I think the access to labor is just not there. I think that in a lot of areas, particularly remote areas, there's just not the labor. It doesn't matter how much you pay them, the labor doesn't exist. So I don't like that aspect of it. But if you're someone that has used H2B for construction occupations, you'll be grandfathered in. So that's great. That means that this gives you a little bit of time. Very little time, but it does give you some time to ensure that if you want to bring in non-immigrant labor to perform construction occupations, then you have the opportunity to do so. Okay, so that's one thing. So if you're a construction company, hasn't been using H2B, may rely on H2B in the future, it's time. You should get involved with the H2B program. That's one of my recommendations. So one of the other bad provisions in this particular bill is the specific exclusion of meat and poultry processors for so bringing H2B workers for meat and poultry slaughtering and processing. Now, the actual implications here, that the reality is that a lot of employers that are engaged in this type of work already struggle to access the H2B program because of their inability to demonstrate a peak load or seasonal need. But there are a lot of them that do. And for those that do, it's definitely not, it's fine if they've used it before, but if you're looking to in the future, it's not going to be good. This is a great question. Why does Kyle insist on those headphones instead of ever popular AirPods? These are AirPod Maxes, okay? The other AirPods are trash, and that is a hill I will gladly die on. These are much better. Anyways, so that's the other bad thing. Now, the good thing, it broadens the cap exempt definition, which is really, really cool. The definition, or I guess not the definition of cap exempt, it broadens who has access to cap exempt workers. If you're an employer that's utilized the H2B program for the prior 5 years, then you would be entitled to have cap exempt workers for the highest number of certified workers you had in any of those individual fiscal years. And that doesn't require one certification. So let's say that you're an employer and you perform work all over the country, and you have 50 labor certifications for 1,000 workers. The 1,000 workers would be cap exempt. And that's great. That's great for you. That's great for people that are looking to utilize this program in the future, because it makes it to where there's more cap space available. So that's actually really, really awesome. The other thing is that it doesn't actually prevent you from increasing the number of workers. The number of workers can increase. It's just that the requested number above the cap exempt would be cap subject. So you would still be fighting for cap space, but again, the cap space wouldn't be nearly as competitive. So that's also really cool. Now, the cap increase is also one of the parts that's pretty cool about this bill. So for those of you that have dealt with me and have dealt with me going on a old man tangent about the logic of a numerical cap, you would know that I despise numerical caps to begin with, because I don't think they make any logical sense. Of course, if everything our politicians did were logical, I guess we'd be in a different situation altogether. But this is what they say about a numerical cap. You need a numerical cap because you need to be able to ensure that these jobs are not adversely affecting the U.S. workforce. Okay. Well, part of the application process is already demonstrating that you're not adversely affecting the US workforce. And if you do, there are some serious fines associated with that. And so, if you're already proving you're not adversely affecting the US workforce, why do you need this arbitrary cap to limit your ability to access the foreign workforce? It doesn't make any sense. Okay. Well, I'll get off my soapbox and I'll just tell you that they plan on increasing the cap to anywhere from 75,000 to 150,000, uh, and it will fluctuate with unemployment. Now, I one thing that I'm not sure about here is if this cap becomes competitive, would they be doing any cap increases? That's one concern I would have with the cap is they would say, "Oh, well, we gave more cap space," and so I don't know. But the reality is that even an increase in cap to say 125,000, 130,000, because it'll be in that range, uh, is really, really good. Much better, especially considering the number of people that would fall within the exemption status. So I think that's great. Uh, One other thing that's actually really cool about this is the dual intent element. So I don't know if you guys are familiar with this legal concept, but all visas have what's called an intent element. And it is, do you intend to immigrate here permanently? You would do this through a green card. Like if you're someone that was just getting a green card, you would immigrate here on a green card. You know, if you were doing let's say you're an investor and you're doing an EB5 investment, same thing. You would hold out to the U.S. government. I intend on coming here permanently. But what you do whenever you're an H-2B worker right now, which is called it's a single intent visa, it's a non-immigrant visa. You're holding out to the government. I intend on coming. I intend on doing my work, and I intend on leaving. And so the cool thing about a dual intent element here is it would allow employers to continue to bring up the H-2B worker while they have a green card pending. Uh, and that's really, really cool. Very, very cool. So that would be a great aspect to it, and it's something that would really benefit people because one of the reservations that you would have right now if you were filing green card applications for someone that you bring on an H-2B, let's say it's in a different occupation, is when you get to a certain point, they might not be able to come back into the United States on an H-2B visa because they have this pending immigrant intent visa, and it could lock them out for a couple of years, and you don't want that. You're probably doing that for your best employees. So that's a great thing to know. And I guess the other thing just to be aware of, and this is kind of the last thing before I'll start getting to some Q&A, is this bill doesn't make you particularly vulnerable if you're already accessing the H-2B program. The thing I don't like about it is it restricts the access to H-2B program for future employers. However, you're fortunate enough to have the opportunity to make sure that your business doesn't fall under that. Now, so from my holistic economic approach, I think, man, I don't like the limiting of H-2B workers. I don't think that that's smart from an economic policy. But from your individual business, if you have concerns about your access to non-immigrant labor, so say you're an H-2A employer and you're worried you can't get H-2A workers to perform a certain job function, or you're a company that's considered using H-2B before, but you haven't started using it, it's a really good time to do that because by being included now, you'll be included in the future benefit of that. So that's pretty neat. Okay, I'm gonna move over to some Q&A. Y'all can ask me any questions that you want. I had one question a minute ago about these labor summits that we do. We do these labor summits where we bring people in to our area generally, and we just get to know them and introduce them to some other like-minded business owners where they can work collaboratively on overcoming any issues they have in their business. And also generally we shoot a lot of guns and fish and hunt. So that's a lot of fun too. So I don't know when we're going to do the next one, but if you want to participate, let me know. Okay. Can you clarify the cap exempt? If we had 5 certifications for 10 people each, and we went through with all certifications, but only brought enough people through the USCIS up on one is our cap at the 10 or the 50. So it is for the number of labor certifications received. One thing to remember about filing applications, and this is just advice, is you're filing for an anticipated need. So there is that. But you also want to make sure that when you're filing H-2B certifications, you're filing for what's called a bona fide need, meaning there's a real job opportunity that's there. Now, I understand that jobs fall through, particularly now. I've seen a ton of jobs fall through just because of material deliveries and that kind of stuff. But there is this notion of a bona fide job opportunity, just to make sure everyone is aware of what that means. It means that whenever you're applying for H-2B visas, you are attesting to the fact that there is a legitimate job there. And so this provision is meant for the actual certifications received, not the number of people that were actually issued a visa. Cap space, is this number divided by 2 for April and October? I would assume so, but I actually don't recall that from my first reading through the bill. And I actually don't know if that would be, yeah, that's something I would have to check on and get back to you. I don't remember. I need to read back through this bill. I don't remember from last time I read through it. Can one do a dual intent with an H-2A visa? So H-2A also is a single intent visa. Yeah, so it's in the same boat as H-2B. Okay, our company applied for H-2B workers for the first time this year, but have not yet been approved. Would that mean that we are grandfathered in or not? No, because this is for employers that have received H-2B certification for the prior 5 fiscal years. Now, if you are a company that's, so that would be for, sorry, by grandfathered in, if you mean you're a construction company, and would you be grandfathered into the definition or to the H-2A program or H-2B program? The answer is once you receive certification, yes. But you do have to receive certification to be grandfathered in. But since this is your first year, this is a great distinction to make. Since this is your first year, you want to be eligible for the returning employer exemption, so your application would still be cap subject. Will you have a copy of this webinar recording afterwards? Yep, always do. You could also, we've got a ton of resources on our website. I don't actually know this, but I think that we post our webinars on our website. If you go to our website, farmerlawpc.com, and you go to the video section, I think they're all there. But yeah, this recording will be available afterwards as well. If one of your questions is how is the volume so unbelievably clear, it's because I'm using AirPod Maxes, not to be confused with the traditional AirPods that get stuck in your ear and make your ear itch and are awful. These are the GOAT of headphones. If you're someone that would be interested in coming to one of our labor summits, just to kind of let you know what that's all about, we actually pay for people to come here. There's a big benefit to us. I'm not reading that one out loud. There's a big benefit to us because we really do value relationships with our clients. It is the thing that I think has actually got us where we are. You know, we've grown remarkably and are extremely grateful to our clients for that growth, because it is through authentic and genuine relationships that has happened. And so we do pay for people to come in here because we don't want the money to be a hindrance to get you here. We do want to have a real relationship with you. So if you're someone that would want to participate in one of those labor summits, just email us at intake@farmerlawpc.com. Okay, cool. So, and then, yeah, how do you foresee the additional demand for H-2B caused by construction restrictions on H-2A? So right now, there's not construction restrictions on H-2A. But if you think about it, let's say that there are 3,000 H-2A construction. Let's say that there are 3,000 H-2A construction occupations certified each year. And then if it got rid of H2A construction occupations, and then that would be forced to go into H2B, it would make H2B that much more competitive. It would be a direct translation. One of our friends and someone that's participated in the summit said that if you want a referral on the legitimacy of the summits, that they can contact him personally. If you email us, I'm not gonna put his name out here, but if you email us at intake@farmerlaw.pc, we would certainly connect you. That is one thing that we've got is people have been, and I do appreciate that. I really do. That's one thing that we've got about these labor summits is people look at it and they're like, why is there not an agenda? And the reason for the lack of agenda is because I don't think that there's as much value in me lecturing you as there is in us having a conversation, because it's not all about labor. I want to know, what are your business problems right now, or what are your personal problems? What can we talk about to make your life better? It's actually all about relationships. So yeah, no, if it's something you guys want to be involved with, just email us at intake@farmerlawpc.com. We have a heck of a time. And no, I do. This client says that he does want to participate, but he's afraid I'm going to shoot at him. I'm not going to shoot at you, and I will also kick your ass in sporting clays. So let's go. Okay, so here's the question. I was a minute or so late hopping on. I heard you talking about the construction workers, etc. Does all this apply to landscaping companies as well? So landscaping companies, this is an interesting question because in theory, no. In theory, landscaping companies would be a pretty good beneficiary of this legislation, even if they haven't participated in the H2B program before, because they are they should be coded as a landscaping occupation. But a lot of landscaping companies also do hardscaping, and I could see the Department of Labor trying to encompass that in an SOC code that falls under construction occupations, which would then exclude you. So the mowing of grass, no. The construction of a deck, probably. For a first-time H2B applicant, is there a timeline to get approved before this law would take effect? Yes. So I guess just to be perfectly clear, perfectly honest, I obviously do not know if this law will pass. And parts of me are hopeful that it will, and parts of me are hopeful that it won't. But I don't know. I think it does have some wind in the sails, which is why we're talking about it so early on. And you would need to be certified prior to the end of the year, I would suggest. And remember, it has to be a bona fide job opportunity. So file certification very, very soon. We're already coming up on deadlines for October filings, which is when the next cap will open up. And so the sooner the better. Kyle also provides a very poor clay shooter, so no one's pride gets hurt. Yes, I do. I will always include some of my team that has not shot guns, so that you can be assured that you are not going to be the worst shooter there. We humiliate ourselves on your behalf. When could these potentially take effect? Next fiscal year? My guess would not be next fiscal year. It would be next calendar year, because it comes in the omnibus packages, which are always at the end of the year. How many construction workers are currently working under H2A? I do not know the answer to that. I would guess several thousand, though. Well, maybe not several thousand. Several thousand certified cases, but that doesn't mean it's several thousand individual workers. So I don't know the answer to that one. Should we up our number of certified workers to have more cap exempt workers in the future? This is from someone that has used the program for the last 5 years. If you have a bona fide need for additional workers, then yes, you absolutely should, because it would give you more cap exempt people in the future. The thing is just make sure you got a bona fide need for the total number of workers requested. And if you do, good, let's go. That's exactly how you should be reading this and planning on this. So that's a great question. Thank you. I actually meant to say that earlier and I completely failed to. So thank you. What if one year we request 50, but one year we only had a need for 16? Which would be under the cap exempt? So first of all, you got to make sure that you're meeting the first bar, which is, am I an employer that has received certification in each of the prior 5 fiscal years? And if you meet that, then it is the fiscal year where you had the highest number of approved certifications. So if you had, let's say you had a need for 50 people one year and only 10 the next year, the 50 would apply. Our biggest problem to date is having applicants denied for no reason. Can you shed any light on how you can avoid this? So applicants, I'm not sure if applicants, can you clarify this question a little bit? Applicants, are you referring to applications like your actual certification to the Department of Labor, or are you referring to applicants as in workers? Okay, individual workers. There's not a great way. So the question is, our biggest problem to date is having individual workers at the embassy denied for no reason. So the State Department is supposed to provide you or provide the worker a document that says the reason for their denial. But the reality is that this reason can be rather arbitrary, such as you didn't demonstrate enough ties to your home country, so we think that you're going to abscond whenever you get there. There's not a great way to ensure that individual workers can come over here because the consulate has a ton of discretion who they approve or deny. But what you can do is, if you are consistently getting that denial, which happens particularly from certain countries really often and at certain embassies really often, is you can take the evidence with you to the appointment that demonstrates why you have to return. Let's say you're married and you bring your marriage license, and your wife or husband is staying back in their home country, or you have kids in your home country, you bring their birth certificates, you've got elderly parents, you bring pictures, and you've got a property that you own, you bring evidence of the property, electric bills, those sorts of things. And that's great evidence to help overcome that hurdle. All right, no other questions? This thing's going to be available. Again, if you have any questions or you want to participate in one of our future labor summits, just email us, intake@farmerlawpc.com. Happy to put you on our list there. And if you have any specific questions or need anything from us, that's also a good email to use, is the intake@farmerlawpc.com. I do appreciate everyone participating in all the Q&A. It's a lot of fun, and it's always a highlight of my week. So I appreciate it, and we will talk to everyone soon. Thank you.